Welcome to the Trial Lawyers Injury Podcast with David Zagoria.
Welcome to the Trial Lawyers Injury Podcast with David Zagoria. David is a former prosecutor with Zagoria Neely Injury Attorneys, representing injury victims across Georgia in serious injury cases. I'm Shameika Rhymes, and today we're talking about what makes a personal injury case high value in Georgia. Welcome back, David.
Welcome. Thank you. Good to be back.
Good to see you. Well, David, people often focus on the final settlement or the verdict number, but what actually drives the value of a serious injury case?
So, obviously, the first and most important factor are what exactly are the injuries. If you have a case with a broken bone, that's going to be significantly more valuable than a soft tissue case where a person is hurt and they go to the chiropractor and they treat for 12 weeks and they're fine. So, the extent of the injuries from a mild to moderate injury to severe, catastrophic, broken bones, surgery, loss of body parts to death, those are going to be your most higher value cases. But even within that spectrum, there can be other factors, really three more factors that determine case value. And the first is going to be, what is the venue or jurisdiction? So there are many counties, wherever you are, whether you're in California, Alabama, Georgia, there are certain counties where you're just going to get better juries. For example, here in Georgia, we have venues where they're college towns. The people are educated. They are smart. They're going to know insurance is covering these injuries. And you're just going to have a better verdict when you're in a better county, as opposed to a county that's very conservative. When you have very conservative counties, typically that'll keep verdicts down. And even if your case isn't in litigation, if you know where the case is going to wind up in court, that issue can be handled with the adjuster to say, hey, we're going to be in such and such county, and that's a great county for plaintiffs. You're valuing this case too low. It should be much higher based on where this case is going to wind up in court.
Okay.
Then another really important factor is the attorney that you choose. If the insurance company keeps track, they know what lawyers and law firms are trying cases. So if you hire a lawyer and it's just a settlement firm, meaning they're going to push you to settle your case, they're going to farm out your case to another firm if they can't get it settled, or they're a case that tries, or if they're a firm that tries very few cases, it's going to lower the value of your case because the insurance company is going to know, okay, this is a firm that doesn't try cases. They're willing to take less. So great, let's give them a lowball offer. They're going to wind up taking it versus a firm that's willing to go all the way, fight all the way through jury trial is going to get you the maximum result. So when you're looking to hire an attorney, make sure your case is with a firm that actually litigates cases and tries cases. And then probably the last factor that's really going to determine case value is how strong is liability. And it's easy in the car wreck world because if someone runs a red light, they're following too closely and they rear end you, liability is never going to be an issue in those cases. The only issue is going to be, how much is the case worth? And that's very different from a case when liability is in question. So if you have a slip and fall, and maybe there's an issue that the injured person should have been paying more attention to where they were walking, or a dog bite case where perhaps there's a defense of provocation. In those cases, that can keep the case from reaching its full value, because if you have a solid offer, you may not want to risk going to trial and getting a verdict less than what a reasonable offer would be, because when liability is in question, it's much more of a risk to go to trial. You could get less than what's being offered. So those are really the factors. I mean, that's the tip of the iceberg. The judge, who the judge is can be a factor, how old the case is, our client. But those are typically the factors we see in sort of the tip of the iceberg analysis of case value.
So something popped up in my brain as you were talking, and just for example, if there is a slip and fall outside of the county where the person lives, would the trial be held there in that county where the fall happened?
That is a great question. So in almost every jurisdiction, in this country, venue is where the defendant is. So the easy example is, Shameika, if you're in a car wreck and you caused it, they have to sue you where you reside. So it's where, and so we don't get to pick, unfortunately. So otherwise, every case would be in the great counties, and then the other counties would have no cases. So it's typically where the defendant resides. Now, if you have multiple defendants who live in different counties, you then can pick which one's better, but you have to have a connection to that county. So for Walmart, it could be where the, a store type case, a Walmart, Target, where the store is or where their registered agent is typically where the venue is going to be. But we typically, as plaintiffs' attorneys, don't get to pick where the case is. That's unfortunate, but that's just the way that is.
Okay. Well, how much does the quality of the evidence affect the way a case gets evaluated financially?
Well, that's a great question. And that's sort of secondary to the first question you asked about how we value cases. And the quality of the evidence is an absolute determinative factor in determining what case value is. And the evidence could be everything from damage photos to the car wreck case. In every case, injury photos. The better the documentation of the injuries from the time of the incident through the healing process, the better the case is going to be. And we're going to want pre-injury photos, especially if they're scarring. So there's a comparison of the before and after photos. Eyewitness interviews, no matter what kind of case, we want to have eyewitness interviews and statements from them if we can get them. Before and after witnesses, talking about what our clients were like before, what life was like before versus what life is like now. There's a treasure trove of evidence that can be found in every case. Video that may have captured the event that caused the injury. There's no end to the list, but the more you have, the better quality, the better your chances of getting your case settled. Frankly, the stronger it is, the less the defense wants to go to trial. The less evidence that we have along that list that we've been talking about, the harder it is to prove our case, the more willing the defense is to push the case to trial with low offers.
Well, some injuries, like you just mentioned, can change a person's daily life long after the initial treatment ends. So, what kinds of long term effects tend to carry the most weight in a case?
So the types of injuries that have a long-term effect that will generate case value typically will be scarring. And those will range in value because the scars to a 55-year-old man like myself are not as valuable or as important to a 16-year-old teenage girl and to her face. So it depends on your client and their demographic, age, will determine the value of the scars. But scars are really important because it's a everyday reminder of what you've gone through, whether it's a dog bite or a surgical scar from a car wreck or slip and fall. So scars are very important. Lost wages. If you are out of work for months, and let's say it's, you bring in home $5,000 a month and you miss 4 months of work, that's $20,000 that a jury can pinpoint and say, there's the lost wages. They lost $20,000. We got to give them the $20,000. Medical bills are just the same way. Oh, they've got $100,000 in medical bills. We have to start our verdict at least $100,000. We're not even talking about pain and suffering, but we're starting at 100 for the bills. And if you have a serious injury that is going to have future care, whether that's wheelchairs, walkers, crutches, physical therapy. There could be possible surgeries that may be required in the future. All that needs to be taken account in what's called a life care plan, where a lot of times it'll be a nurse or doctor who will examine the client and determine what the next 10, 15, 20, 30 years will require in terms of medication and care. And that can be built into the case. And that's real easy for juries because they can see a number and say, these are the numbers. We're going to start with these numbers. And then we're going to talk about the pain and suffering, especially when you get into jurors with people who might be the engineer types, accountants. They want to see numbers. And it's real easy for them to grasp those numbers before we even get into the issue of pain and suffering, which is the big number, especially for someone who's hurt really, really bad.
Well, that's my next question about the pain and suffering. How is that number determined?
That number is determined by the enlightened conscience of an impartial jury. And if you know what that means, you're way ahead of me. So it really just means, what do you think is fair? And when we're getting to pain and suffering, we're talking about quality of life. And the biggest example I can give of that is we want to talk about what's been taken away, because that's what happens to people when they're hurt really bad, is their quality of life has been taken away. So you're right. It's pain and suffering. What does that mean? And
Yes.
it's much easier if we come up with concrete examples of how life was before and what's been taken away to make it different now. And when we talk about what's been taken away, jurors will understand and empathize with what is it that this person loves that's been taken away. So when we get in front of that jury, and even with a demand letter, honestly, I want to talk about what my client loves, whether it's fishing, running, gardening, swimming. I've had a client that's a disc golfer that couldn't play disc golf anymore because of their injuries. And we want to talk about why that's important to them, what they get from it, and how that's been changed. And it may not be taken away forever. Maybe it's been taken away for a time, or it's just different. They can do it, but it's just not as enjoyable.
Mhm.
And when we start getting into that conversation with jurors, they understand pain and suffering because they then can relate. You got to, you have someone on that jury who's they do pottery, and
Mhm.
my client has a hand injury, and they're like, oh my goodness, if this happened to me, I wouldn't be able to do my pottery. And all of a sudden, you start getting big verdicts for pain and
Mhm.
suffering.
Oh, okay. Well, how does disputed liability affect the value of a case, even when the injuries themselves are very significant?
You know, unfortunately, it really has to be taken into account, because one of the things I never want to have happen is to turn to my client after a trial and have to say, I'm sorry, because our verdict is less than what the offer was prior to trial.
Yes.
And that can happen in any case, but it's most likely to happen when it's a legitimate liability issue.
Mhm.
Now, the defense may try and make the case a liability issue, but it may not be bona fide. But when it truly is bona fide, and we see that a lot in slip and fall cases, we've seen it a lot in dog bite cases. It's not as often in car wreck cases. Those are much more clear cut, but it has to be taken into account in determining the offer. Now, it's real easy. We're about to go to trial on a case right now where it's a broken bone case with surgery. Liability, they're disputing it, but it's not that bona fide, but they're only offering a very small amount. So that makes it real easy.
Mhm.
Let's go to trial. We're not really risking much. So what I'm saying is there has to be a risk analysis done, meaning the more liabilities in dispute and the more money they're putting on the case to get to a number that's reasonable, the client has to start thinking about taking it. Now, the more liabilities in dispute, but the number that they're offering is low, there's not really a risk analysis. The risk analysis comes from a reasonable offer versus what are we risking going to trial? How much can we beat it by? But if we lose, how much worse are we going to do? And it's a very important conversation to have with the client. It's a very important analysis that's got to be done so that when the trial is over, we don't have to say that to the client, I'm sorry that we got a verdict that we're not happy with. And that is the whole point of the risk analysis conversation. And the insurance company and their defense lawyers are having the same conversation in their conference rooms about our demand and what their risks are if things go sideways for them.
Well, then we have to throw in the insurance company policy limits because that can create some limitations in some cases. So, what options exist when the damages may exceed the available coverage?
And that is something that is very, very frustrating and difficult. And it's really hard to get your mind around it. So, first of all, I would say for everyone who listens to this podcast, buy uninsured motorist coverage for yourself, at least 200 grand, because that way, if someone wrecks into you, and let's say they stole the car and there is no coverage, your own insurance will provide you protection. It's called uninsured motorist, or if they have very low limits like 25, it becomes underinsured motorist, where your own insurance will pay for your medical bills, pain and suffering, and lost wages. Now, you still may have to sue, but your insurance will be the one that cuts the check when you get a verdict. And it's very inexpensive. If you don't have that, you may be stuck in a car wreck case for low limits, say 25 grand. We've had it in dog bite cases where we've had catastrophic injuries and there were low limits. Now, in a slip and fall, you don't usually have it because you're usually dealing with a corporation, a Walmart, a Target, and the money's not going to be an issue. It's typically when you're suing individuals and not corporations. And you really only have two options. You can take the money, or you can try and sue the individual and have them pay themselves. We have done that before, but it's been with defendants who are very wealthy. They were underinsured or had no insurance, and their insurance kicked in the policy limits and said, here's our money, we're out. And they left their insured out on their own, and we sued their insured. They had to defend their insured, and they had a lawyer, but then the insured had to come up with their own money. We've had defendants who've refinanced their houses, who've cut checks. But the bad news is if the person has very little assets, they don't own their own home, and we go get a judgment, they can file bankruptcy, and they can list the judgment as a creditor and discharge all or part of the judgment, and our client would get nothing. So you got to protect yourself with coverage.
Thank you for that. This conversation has been so informative and just so good, David. But I want to thank you for breaking this down for us today. This has been, like I said, very helpful, especially learning about the coverage. So thank you.
You're welcome.
Well, that is it for today's episode of the Trial Lawyers Injury Podcast with David Zagoria. If you'd like to learn more about David Zagoria and Zagoria Neely Injury Attorneys, visit lawzagoria.com. Thanks for listening, and don't forget to subscribe, leave a review, and share the show with someone who may need trusted guidance after a serious injury.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.